Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Hello everyone, and welcome to another episode of Empowering Plans with the FIA Group. This is not your host, nor is it ever really your co-host, but the wisest of you will know that this is what Ron Peck would refer to as the Triple P, the Triple Threat, podcast producer Pat, helming the intro for this episode. Joining me today are Maribel and Cindy, two of our attorneys. Well, let me not distract you from today's topics much longer. Let's hear what they have to say.
Hey, Cindy. How's everybody? I hope everybody's doing well. We're here to talk a little bit about subrogation and reimbursement. Although they are terms that are used interchangeably, they don't often mean the same thing. So let's get started, Cindy.
Hi, Maribel. I'm calling you from our office in Louisville. It is absolutely stunning here today. So I hope everything's going well up in Canton.
Everything's doing well. The Sun is shining.
Good.
So we're doing all right.
I am a senior recovery attorney here. I do subrogation all day, live, eat, and breathe subrogation here. So I love it.
That's awesome. I think I'm in the same boat. I've been a subrogation attorney for the last 5 years. And before that, I was a plaintiff's attorney. So I have a little bit of background in that respect.
So I was also a plaintiff's attorney. And, it's nice. I think it gives us a little bit more of a comprehensive look and background to subrogate cases.
For sure. I think one of the things that we are coming across is this difficulty in resolving claims with attorneys. We're coming up in this post-COVID world where courts have been closed for the last year. We've had insurance adjusters causing issues. So I'm sure you've come across some of these issues, right, Cindy?
Yeah, COVID affected all of us in everyday life, but it's also affected us in subrogation. So I think in New York, their courts have been closed for a very long time, but across the country, they've been closed as well. And the insurance companies just don't have that threat of trial sitting out there anytime soon. And so they kind of been sitting on some claims.
Oh, yeah, I agree. I think California and New York were the last ones to reopen. And even still, I think California is still doing virtual hearings for some of their things. So yeah, definitely. I think it's been a long time coming, and hopefully a lot of these claims that have been sitting in the hopper resolve relatively quickly.
Yes, we also have it not only on the front end when we're trying to get claims resolved with the at-fault parties, but once all the parties come to some kind of an agreement, the court, as you may recall, have to approve all those settlements. So it's just now what would have been, 3 to 6 months for a minor settlement is I'm finding to be more than that. How about you, Maribel?
Oh my goodness, yes. We have claims that were resolved prior to COVID, and then the courts closed, and we still haven't been able to get a judge to approve these settlements. So yeah, we're up against the gun a lot of times when, the adjusters and the attorneys are basically telling us their hands are tied because they haven't gotten an order from the judge approving the settlement.
Yep, I've noticed that as well. I also have noticed that we're having a hard time where the courts are not able to adjudicate some of these cases quickly, where typically they would be done in a motion hour, whether or not some pieces of evidence can come into play, which would then put pressure on the insurance companies to settle. And we're having just such a significant delay. And I'm hoping that can resolve now that things are finally opening up again.
Yeah, I'm very hopeful. Even still, we're running into the issue of policy limits. Some of the things that people did to cut back on costs when COVID hit was to change their policies and reduce them down to the state law requirement. And so one of the things that we're coming across with newer accidents is there just isn't enough money to go around.
I've noticed that too. And, when we have places out there and some of the things that come off the top of my head are California. There's only $15,000 in policy. That's the state minimum. $15,000 hardly gets you very much in medical treatment, if anything. And that's a tough spot when the plan has paid more than the policy limits repeatedly,
Yeah, it's definitely more prevalent in the last couple of months. I've seen this come up a lot. And especially when you're coming across smaller policy limits, and the adjusters are being difficult in trying to basically shortchange claims. They're nitpicking and they're, ripping apart members' medical records, and they're not allowing recoveries to plans. They're just being very difficult.
I agree. I've noticed that as well. One thing that I think is something to ponder is if someone did get into a motor vehicle wreck, but they didn't seek immediate medical treatment because of their concerns with COVID, my concern is that maybe we might start running into it more where there is a delay in that treatment, but it was caused by that wreck. And so that is another thing that I think I could foresee happening in the future. We were already running into them nitpicking the medical causation. So did the wreck cause the member's injuries? But one thing I've noticed is some people didn't want to be in the hospitals. So they didn't want to be out and exposed to COVID, understandably. But now they're still 6 months later having back pain or neck pain. Are those caused by the wreck? That's something else I think we might run across more and more and more in the near future.
Oh, yeah. And I think plaintiffs' attorneys are between a rock and a hard place in, one, trying to resolve these claims, but then on the other hand, setting the expectations for their client, which would in turn be the member, in advising them, this is going to be an issue, right? If the plan pays for claims that may be related to the accident, their job is to ensure that the plan gets reimbursed. And so if the adjuster doesn't correlate these claims, how do they make the argument to the adjuster that this is something that's definitely reimbursable to the plan and to the member as part of their pain and suffering claim?
And at the beginning of this podcast, you made it very clear that there is a difference between subrogation and reimbursement. And are we now as plans going to be in a situation where when we're pursuing reimbursement from the member, it's actually likely more cost efficient for these plans to do it through reimbursement if this medical causation issue is coming up, because they're the ones who know their medical history and can testify to that and their experience for that. So that's another reason why reimbursement is typically cost effective as opposed to subrogation for the plan.
Oh, yeah. I think reimbursement claims have always been cost effective. I think when we talk about subrogation, I think it's hard to have a suit filed on behalf of the plan participant when the plan participant isn't helping the claim or isn't participating in the defense of the claim. And ultimately, if they're not going to make anything out of it, one of the main issues that we come across is they're not going to make anything or they're not getting a recovery. They're not really interested in trying to pursue these claims.
Exactly. And with medical causation, that's one of the biggest defenses that we run into. When medical causation is the linchpin, that is something that reimbursement is definitely the way to go.
Oh, yeah. I mean, I understand, sometimes the plan documents have the language for 100% reimbursement. And one of the things I think Chris Aguiar has a habit of saying, you'd rather have the gun when you come to a knife fight in the event that you need it, right? You have the language necessary for it. But sometimes in these cases, especially when there isn't enough money to go around, the discussion of a reduction usually comes up.
Exactly. And that's a part of what we try to do to assist plans in getting a maximum recovery when we have limited funds. So in an example, when the plan has paid $50,000 out there in benefits and there's only $15,000 in policy limits, that means likely that person who has $15,000 policy limits doesn't have any assets in which anybody could pursue. They're judgment proof, which means that $15,000 has to somehow compensate the plan and, like you just discussed, give the member incentive to want to settle and participate in the plan. And the attorney who's also presenting not just the medical bills, the attorney is presenting the member's other elements of damage, which means that possibly lost wages or pain and suffering. So it is difficult when we have these low limit, big bills, and even if you have the best plan language, the FIA language, it is very challenging to pursue 100%. You're going to have to litigate those files. So I would highly encourage discussion of reduction.
For sure. Yeah. I mean, as much as we always want to obtain full reimbursement if there is enough money, on cases like this, there's the threat of litigation, and then there's the threat of throwing good money after bad, right? You don't want to have to hire counsel and file suit and do all these things when in reality, the same pool of money still applies. It's the same $50,000 policy, regardless of litigation. And, having to spread that money out even more so in adding another attorney, the goal would be to resolve it amicably so that there is an opportunity to recover more money.
And in some cases, the plan, if they choose to litigate, the issue we have is that sometimes there's that risk of getting nothing. The plan could, in theory, a judge might not see it the plan's way. No matter how awesome that language possibly could be, they might find some way to not get the plan back, the money the plan has paid. There's always that risk.
Yeah, and we have to remember, judges are former plaintiffs' attorneys, right? If it's a judge that is a state court judge or comes up through the federal system, for the most part, they started off probably where you and I started off, down at the bottom level as associates in a small plaintiff's firm, and they made their way up. And so, sometimes they look at plans a little differently if they have pursued claims on behalf of plaintiffs.
Exactly. With that said, though, there are some good things coming, I think. Although I do see some issues that we are currently experiencing, like anything with COVID, I think that those are moving towards resolution now. The courts are starting to open up, and I think that there's also more and more drivers. So I think there's going to be more opportunities for subrogation out there.
Oh, yeah, I agree. I think now that we're at this post-COVID climax, so to speak, we're opening up, we're having more drivers on the road, we're having more claims being presented, hopefully more people are treating, they're not going to hesitate because they're now vaccinated to go into a physician's office or a hospital. I think there are definitely going to be more opportunities for recovery. And, with that said, I think you're right, Cindy. I think with the courts opening up and claims being presented, I think adjusters will be more advantageous to try to resolve these claims prior to litigation.
All right. Well, I appreciate this conversation we had today because I think that although subrogation is old, it is still constantly changing, and it is a wonderful opportunity for plans. And I love subrogation, and I'm looking forward to subrogating post-COVID.
Definitely. Thank you for this conversation, Cindy, and everybody else who's listening. I think this is a great opportunity to understand, even though subro isn't sexy anymore, we are definitely doing our best to recover the maximum amount possible for plans. And, we're doing the best as far as getting all the money back that has been paid where the plan isn't responsible for paying them.
Thanks again, Maribel. Thanks again, Cindy, for joining me on today's podcast. And thanks again to you, the viewer, the listener, those of you who have stuck around to the end. But unfortunately, that's all the time that we have for today. So on behalf of myself, podcast producer Pat, and the rest of the FIA group, we hope that you tune in next time for the next episode of Empowering Plans with the FIA group. Have a great day.